All right, what are we doing?
We are here for a pretrial and also a bond violation report.
Yes.
So, given the results,
Do you have her bond violation?
What happens when a mother, working two jobs, stand before a judge with cocaine in her system, a diluted drug test, and a second DUI charge hanging over her head? Today, we're breaking down the case of People versus Whitney Mitchell, a woman who claims she wants to change, but whose actions tell a completely different story. The judge isn't by her excuses. Her freedom, her job, and her relationship with her 15-year-old son are all on the line. But here's the real question. Is Whitney a victim of addiction or someone playing the system? Buckle up, because this courtroom showdown is about to get intense. Let's dive in.
Go ahead.
so there's a couple of things. I guess there's three kind of things to address here. The first is the cocaine. Miss, I could talk to Miss Mitchell about it. She did pass the day after her arraignment. She denies using cocaine after her arraignment. This was her first test after being ordered on bond. And her arraignment was on the 17th and the test was the 18th. So her assertion is that it was from prior to given the bond conditions. Regarding her use of cocaine, however, she has seen a doctor at the University of Michigan where she is beginning the process to enroll in treatment there. She has an appointment tomorrow at 2:30. And they are, the letter that she provided me that's dated today says that they've spoken with the addiction treatment team and are working to place her into intensive treatment and detox services. And tomorrow will be the follow-up appointment. Regarding the THC, she does have a medical marijuana card and did provide that to community corrections. And
What about her diluted sample? Go ahead.
yeah, the dilute is the third piece here. I asked her about it. I also tried to get kind of a definition from community corrections. I didn't receive one, but her explanation was that she woke up, didn't eat anything, drank some water, took her kids to school, and then went to community corrections, as is her normal routine. She didn't have any insight into what happened, and I don't know why. We both don't know why it would be diluted. We have no explanation for that. She was very clear with me that she did not try to skirt community corrections or anything like that. She said she wouldn't even know how to.
Okay, let's break this down for a second. We've got three major red flags here. First, cocaine in her system the day after arraignment. She claims it was residual from before. Second, THC positive. But she's got a medical marijuana card, so that's technically allowed. And third, a diluted sample. Now, for those who don't know, a diluted drug test happens when there's too much water in your system, which can mask the presence of drugs. Courts and probation officers see this all the time, and it's often viewed with extreme suspicion. Whitney's explanation: she just drank water in the morning. But here's the problem. When you're already on thin ice with a cocaine positive test, a diluted sample looks like you're trying to cheat the system. This is not a good look, and the judge is clearly skeptical.
So, given all that, Your Honor, my request is to keep her out of custody, let her go to this appointment at the University of Michigan, see if they can get her into treatment and detox. She is employed. She has two jobs and a young child. She works at the University of Michigan and at Five Guys. How old's her son?
He's not young. He's 15,
Oh,
but
15.
I still care for him every day. Drive him back and forth to school, cook him dinner.
That's this individual with, I have a second offense operating while intoxicated at this point on this case. That is alleged to have occurred back in June. And I have a test result that shows up on the 18th as positive for cocaine. Her next test, though, is a diluted sample.
Can I speak?
Yeah.
So with that was I wasn't doing any drugs like cocaine or anything. I was smoking marijuana and then I'm like, I remember I called and asked, is it okay if I can smoke? And they were like, we don't know. Then I found out yes. So I drank some bottles of water before the test, but I didn't do any hard drugs or anything. And I just really want to stay out so I can keep my jobs and stuff. And I can, because if I lose the job, then I won't be able to go to the treatment because I won't have the insurance.
Wait, hold up. Did she just admit to drinking multiple bottles of water before a drug test after already testing positive for cocaine? Look, I get that she's trying to explain herself, but this is the kind of statement that makes judges' eyebrows shoot straight up. She's essentially admitting that she deliberately hydrated before the test because she was worried about the marijuana showing up. But here's the thing. When you're facing serious charges and you're already under scrutiny, this looks like manipulation. And now she's invoking her job and her insurance as reasons to stay out? The judge is about to make it very clear that excuses aren't going to fly in this courtroom. Watch what happens next.
Yeah. It's a horrible circle you placed yourself in.
Yes, it's all my fault.
Oh, it absolutely is all your fault.
I have a problem and I'm willing to try to get it fixed now. I
Is that
I'm
before or after you kill somebody with a car?
I
I mean,
don't,
this is your second offense, or at least alleged second offense.
Your Honor, I don't plan on killing anyone. I really plan on.
Nobody ever does.
Okay, I'm sorry, Your Honor. I just want to stay out for my son and my job.
So when you were doing the cocaine, how much were you thinking about your son?
I wasn't thinking. I was thinking about myself then, being selfish.
So why are you bringing him up now, saying you want to be out with him when you weren't thinking about him when you were doing the cocaine?
Because to see the look on his face when I told him I was coming, and to think to prioritize that stuff ahead of him, and what the good stuff I finally do have going in my life. When I start doing good, I just want to be on a straight and narrow and get clean and stay out. I don't want to have to start from scratch. No, my mercy is in your hands.
This right here is the moment that cuts to the core of this entire case. The judge asks a simple but devastating question. When you were doing cocaine, how much were you thinking about your son? And Whitney admits she wasn't. She was being selfish. That's raw honesty, and you can see the weight of it in her words. But here's where the judge makes an incredibly powerful point. She's invoking her son now, when she's facing consequences. But where was that concern when she was making the choices that put her here? This is what judges see all the time. Defendants who suddenly find motivation when they're staring down jail time. The question is this genuine change or is it survival mode? Let me know in the comments what you think.
Here's the thing I don't get. The test results from June 30th show in her system alcohol, methamphetamine, and cocaine. That's at the end of June, very beginning of July. So you're sitting up here telling me you're sincere about this, invoking your son, doing all of that stuff, yet 3 months later, or a little less than 3 months later, I still have cocaine in your system.
It's an addiction problem.
What?
It's an addiction problem.
So when exactly did you figure that out?
Now I'm going through all this stuff.
Yeah, you want to get here. You're an addict. You're going to get here and try to tell me anything and everything in the world to try to keep yourself out of trouble and keep from being accountable. That's what you're doing.
I just want to keep the positive things going in my life. I'm willing to admit my wrongs. Like,
Methamphetamine, cocaine, and alcohol all in her system at the same time back in June. Let that sink in for a moment. This isn't just recreational drug use. This is a dangerous cocktail that the judge literally says he's surprised didn't kill her. And she got behind the wheel of a car in this condition. This is her second DUI offense. The judge's point is crystal clear. She's been using for months, and now that she's caught, suddenly it's an addiction problem that she needs treatment for. But the judge isn't having it. He sees through the excuses and calls it exactly what it is. She's saying whatever she thinks will keep her out of jail. The accountability is nowhere to be found, and the judge is about to make that painfully clear.
Anything else?
Well, Your Honor, I'd ask that you take into consideration the fact that she does have an appointment tomorrow to address,
I don't
Her
know what
addiction.
game she's playing. She's playing a game.
if the court
If
does,
she was really serious about it. I mean, what right now is causing her to do all of this? Being in court? Well, she knew she was headed there from the time that she got stopped on this. And why is it taken over 30 days from the time of her arraignment for her to have this appointment?
I work 2 jobs. I just don't want to lose everything.
and Your Honor, we have been in communication. We talked about this. She's willing to do treatment. I think she's admitted to the court that it would be helpful for her. I agree. On a lot of these cases, it's helpful, right? I guess I'd ask the court to take that into consideration today. If the court does remand her,
I don't know what she's going to do the moment she walks out of here. I have no idea.
I'm going to go to work.
I have no idea what she's going to do. The sad fact of the matter is, I don't think she does either. Because the cold hard reality is, June, she's picked up. She has cocaine and meth in her system, as well as alcohol. So I'm surprised she's not dead. She has a previous drunk driving before that. So between the end of June, so let's just say the beginning of July, coming up into September, she's still using.
yeah,
And then when all of that kind of catches up with her, now I'm going to get myself enrolled in treatment, or I'm going to get myself enrolled in this. But even from the point of the time that she first saw me on the 17th of September till now, she hasn't done anything. Really. She's got an appointment tomorrow. How come that appointment isn't taking place 4 weeks ago, if not 3 or 4 months ago, quite frankly?
Oh, I just work so many hours and just try to take care of our kid. I should have made it 3 weeks ago, but I'm trying to take.
You got an excuse for everything. Yes. Everything coming out of your mouth is an excuse.
Everything coming out of your mouth is an excuse. The judge has had enough. And honestly, he's making a valid point that we see in courtrooms across the country every single day. Whitney says she works 2 jobs. She says she's trying to take care of her son. She says she should have made the appointment weeks ago. But every single explanation is followed by a but. The judge is pointing out a hard truth. If she really wanted to get help, if she was really serious about changing her life, she wouldn't have waited until she was facing jail time to schedule a treatment appointment. Actions speak louder than words, and right now, her actions are telling a very different story than her words. The moment of truth is coming.
I just want to do better.
if I am able to communicate with the doctor and coordinate some kind of plan moving forward, can I submit that to the court for your consideration?
Certainly you may, but you can have a plan, but then she's going to need to do it. Because I'm going to tell you right now, She's coming before me. She's telling me everything that she's telling me, but she's lying to me like she's been lying to everybody in her family and everybody around her for I don't know how long, but certainly over the last year. Well, young lady, game's up. You may have just run into the immovable object. If you're going to tell yourself that you're going to do this, then you're going to do it. But you're not going to come up here and just kind of give me this and that. And I'm going to do this and this is why and everything like that. If you want to make a commitment, then you make the commitment. And you got time to think about the commitment. Defendant's bond is hereby ordered revoked. I will adjourn the pretrial hearing to next week on the 22nd. And she can come here with a better plan than what she's got now. 9 a.m. on the 2nd.
And there you have it. Folks, the gavel has fallen on the case of People versus Whitney Mitchell. The judge revoked her bond, meaning she's going into custody, at least until her next hearing on the 22nd. But he's giving her one more chance. Come back with a real plan, not just promises and excuses. Let's recap what happened here. Whitney Mitchell, facing her second DUI charge with methamphetamine, cocaine, and alcohol in her system, tried to convince the court that she's ready to change. But the judge saw through every excuse: the diluted test, the last-minute treatment appointment, the constant invocation of her son, and her jobs. His message was clear: game's up, actions matter more than words, and if she's serious about recovery, she needs to prove it. This case raises some serious questions about addiction, accountability, and the justice system. Should courts give more leniency to people struggling with addiction? Or is the judge right to demand action before words? Drop your thoughts in the comments below. I want to hear your take on this one. If you found this case as eye-opening as we did, make sure to smash that like button, share this video with someone who needs to see it, and don't forget to subscribe to the channel for more jaw-dropping courtroom breakdowns just like this one. Hit that notification bell so you never miss another case. Until next time, stay safe, stay informed, and we'll see you in the next video.